Okay, we're on the record in two cases. First case is cause number 329-106. Second case is cause number 329-188. Both cases are styled the state of Texas versus Dan Shelton the third. We have Mr. Shelton appearing via Zoom. We also have Mr. Charles McIntosh, who
Yes,
is
Your Honor.
who's appearing via Zoom, and also have a motion to substitute counsel that was filed by Mr. Attorney Langston Adams, who is also appearing via Zoom. Is that correct?
Right.
Okay, now, Mr. Adams, I'm looking at your motions to substitute in both of these cases. You state that the defendant no longer desires to be represented by Mr. McIntosh, and that you have been employed to represent Dan Shelton III. Is that correct?
Right.
And Mr. McIntosh, I know last week you had mentioned this case, and you've received notice of this motions to substitute. Is that correct?
Yes, Your Honor.
You have any objections?
No, Your Honor.
Okay, and I see that Mr. Shelton here. Mr. Shelton, you consented to the motions as well?
Yeah.
Okay, so you've been hired. So what we're going to do, the court is going to sign the orders in these cases. This case,
And we're requesting you sign my other order for the testing.
okay, we need to
On a
have,
motion for testing as well.
okay, well, we need to, pursuant to, I think Article 42, no, 42B, we need to have an informal inquiry. We can have an informal inquiry. We have to have an informal inquiry prior to the court signing that motion. Let me see. I'm signing this motion to substitute right now. Today is May the 20,
I ain't had a vacation in 20 years.
2021.
$3.8 million.
May 20. Oh, yes, hold on a minute. Okay, here you go. These two motions have just been signed. Okay. Now, Mr. Adams, I've just signed these two motions, so you are, you'll be officially the attorney of record for Mr. Dan Shelton III.
You can make this speedy trial, man.
Okay,
Give
so,
me probation, so I ain't gotta do nothing. I don't even know where these charges come from. I came in here on Easter Day.
okay,
These
Mr.
charges. I got
Okay,
brought in by Officer Tran.
Okay, Mr. Shelton.
Officer Tran asked me if he brought me in on Easter. And if his testimony let me know that I came in on Easter to say these charges were not on their computer file, they false charges. I came in on Easter. Those
Okay.
are false charges. It's
Now,
a 6-year-old trespassing. They got new management at OW Collins. It's not even the same people who put me on trespassing. And the indecent exposure.
Let's go. Get your mouth. Grab your mouth. Let's go.
Okay. What? Okay, so Mr. Adams, we need to conduct.
I just want you to get the order for the
We
psychological on
I know,
the
we still
sanitary competency.
Yeah, we still have to, conduct a formal inquiry.
Well,
So what I'm saying is we can, I mean, if we could, who's the prosecutor on this case?
I don't know.
Judge, I'll step in on.
I guess that would be.
Is that,
Raymond.
okay, who's the prosecutor?
Your Honor, I'll step in on this and just the little inquiry that we just had, the state supports a motion to have him evaluated.
I mean, the court, there's certain questions and stuff we can have an inquiry. So let me do this here. Let me do this here. 42B. Oh, it's 40, it's actually it's 46B. I say 42B. Okay, yeah, 46B. Here we go. Okay, Mr. Monty,
Yes, there, Your Honor.
could you bring Mr. Shelton back in?
They've already sent him back to his dorm, sir.
Well, you removed him. The court didn't say the court was complete. Okay, just hold on. We're gonna get Mr. Shelton back in so we can conduct this informal inquiry pursuant to Article 42B.004. Could I see his motion?
What's the house number?
329106, cause number 329-188.
Okay, so 106.
And it's a motion, I guess, for evaluate competency evaluation.
Regarding.
They're getting him back.
I need one on each one of the cases.
Okay. And you said the second one was 329.
The cause number
Mhm.
is 329-188. Mel, you got having that same problem with your volume again. We didn't hear anything. It sound garbled. So you're gonna have to maybe come into the courtroom to tell us we can't hear you. Okay. Are the orders attached to this?
The only order I see in them is a proposed order on motion to such.
Oh, okay.
Yes, ma'am. It's all recommended.
Yes.
Melanie wants to know if you signed the order for her to take.
Yeah.
That's right back. For Dan Shelton? Is that who you're looking for, Melanie?
Yeah, that's both of them. I just signed both of them.
Okay. Yes, I have the orders, with your name and everything.
Okay. Hold on, man. We're getting ready to go on the record. Okay, we're on the record in cause numbers 329106 and cause number 329188. Both cases are styled the state of Texas versus Dan Shelton III. We have Mr. Shelton appearing with his attorney, Mr. Langston Adams. We have the state appearing with his state assistant district attorney, Mr. Raymond Shear. The court has before it, in each case, a motion for examination regarding incompetency. The court is going to conduct a informal inquiry pursuant to 46B.004, the Texas Code of Criminal Procedure. Now, Mr. Adams, Article 1.24 states that the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365 Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests such as interest in security, preventing the disclosure of non-public information, or ensuring that a defendant receives a fair trial. Are you requesting that this case be closed to the public, or are you not requesting that?
I'm not requesting.
Okay. Okay, so, let's see. Now pursuant to Article 46B.024, the court must consider factors in this examination. Now, Mr. Adams, you have advised and counseled Mr. Shelton in these cases. Based on your consultation with Mr. Shelton, does Mr. Shelton have the capacity during a criminal proceeding to rationally understand the charges against him and the potential consequences of the pending criminal proceedings?
I don't believe so, but I would rather for him to be tested for it to be confirmed.
Okay, but I'm just asking you based on, okay, now next question. During your consultation with Mr. Shelton, was he able to disclose to you any pertinent facts, events, or states of mind?
No, not with any kind of sense of cognizance.
Okay. Have you been able to engage in a reasonable, has he been able to engage in a reasonable choice of legal strategies and options?
No,
And does he understand the adversarial nature of criminal proceedings?
no,
Now, the next question is, he was in here earlier, and the question is regarding, has he exhibited appropriate courtroom behavior? I will note, just for the record, that prior to Mr. Shelton being removed by Deputy Monty, his courtroom behavior was, I guess, inappropriate. Also, is there any,
I don't know, it looks like it's right next.
do we know anything about Mr. Shelton's personal mental history?
yes,
Okay. Now, is he a person who has been diagnosed with a mental illness or is a person with an intellectual disability?
yes,
Okay, so which one is it, or is it both? Intellectual illness, mental illness, or intellectual disability?
both.
Both? Okay.
So 159. Thank you.
Now, now, do you know, Mr. Adams, whether or not Mr. Shelton is taking any psychiatric or was prescribed or taking
Yes,
any psychiatric or other medication?
yes, he was prescribed medication.
Okay. And is that medication necessary for him to maintain his competency?
A doctor would have to answer that question.
Okay. Mr. Adams, is there anything else that you would like to put on the record to support your motion in this here?
No.
In this hearing? State, do you have any thing that you would like to put on the record?
No, Your Honor, we do not.
Okay. And just for the record, Deputy Monty, would you
Yes,
please
sir.
raise your right hand? And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, you may put your hand down. Now, Deputy Monty, prior to the court conducting this hearing, did Mr. Shelton have to be removed?
Yes, he did, Your Honor.
And in your opinion, was he exhibiting appropriate courtroom behavior?
No, he was not, Your Honor.
Okay. All right. And okay, so at this time, the court is going to find that there is some evidence that raises the issue, and as is in Green versus State, 264 Southwest 3rd, 271, to suggest that, the court finds that there is some evidence from a credible source that the defendant may be incompetent, and the court has conducted a formal inquiry. Okay, so at this time, now, Mr. Adams,
Yes, sir.
we have a motion. Do you have an order for the court to sign? To
I
this,
can give you one. I think last time I thought you did your own, but I can give you one. I can upload one today.
okay, and you're gonna do it in both cases, is that correct?
Yes, sir.
Okay, so this will conclude the this formal inquiry. Mr. Deputy Monty, you can take Mr. Shelton back.
Thank
Mr.
you, Your
Shelton, have a
Honor.
blessed day.
Okay. Mr. Dahl is here. You want me to call him?
Yes.